7 days after giving birth, I walked into court. My husband tried to take our daughter. Having no idea, I held the power to destroy his entire empire.
My name is Maya Covington. 7 days before I walked into a courtroom in downtown San Francisco, I was still learning how to hold my daughter's head up without thinking about it. 7 days postpartum, running on maybe 3 hours of sleep at a stretch, and somehow I was expected to sit across a table from my husband's legal team and negotiate away my own life like it was a line item. Divorce doesn't wait for you to heal. It doesn't care that you're still wearing a hospital bracelet in a drawer because you forgot to throw it away. It starts on whatever schedule the lawyers agree to, and you either show up or you lose by default. I showed up. My body still felt like it belonged to someone else. Sore in places I hadn't expected. Sore in places nobody warns you about. Moving through the world at half speed while everyone around me operated at full. Nobody in that courthouse was going to slow down for me, so I didn't ask them to. 7 days earlier, in a delivery room at UCSF Medical Center, Julian Reed had been present for the first 40 minutes, then stepped out to take an investor call he said he couldn't miss. He didn't come back for almost 4 hours. A nurse asked if I wanted her to hold off logging the birth time until my husband returned. I told her to write it down exactly as it happened. Some part of me already knew I might need that timestamp later. I just didn't know how soon. When Julian finally walked back in, he kissed my forehead, apologized for the call running long, and asked if he'd missed anything important. I told him he'd missed his daughter's first 4 hours of life. He laughed like I'd made a joke. I want to explain who I was before that morning, because nothing that happened later makes sense otherwise. My maiden name wasn't attached to anything anyone in San Francisco cared about. That was on purpose. I'd spent my adult life being underestimated, and at some point I stopped correcting people about it, because being underestimated is one of the most useful things a person can be. The hearing was set for 9 a.m. at the family courthouse on McAllister Street. I stood outside in a coat that wouldn't quite close over the swelling I still had, watching my breath fog up in that gray San Francisco cold that never fully commits. My attorney, Renee Castellano, met me on the steps with 2 coffees from the Pete's on the corner. She looked at me a beat longer than she needed to. "Don't smile at him in there," she said. "He's going to smile at you. It's for the room, not for you." I wasn't planning on it. Good. Security took its time, the way it always does at 9 a.m., when half the building is about to have their lives rearranged. A marshal ran a wand near my hip and apologized when it beeped against the surgical staples still under my coat. He asked quietly if I needed a chair before I went through. I told him I was fine. I wasn't, particularly. But there's a specific kind of fine you learn how to perform once enough people are watching to see if you'll crack. There was something almost funny about being checked for weapons the same morning someone was about to try to take my daughter with nothing but a folder. The hallway outside courtroom 4 already had a dozen other people waiting on hard benches, tired the way only family court makes people tired. Not sleepy tired, worn down tired. A woman near the water fountain was quietly coaching a teenage boy through what to say about which parent he wanted to live with. I was grateful, in a strange way, that my daughter was 7 days old and couldn't yet understand a word of what was about to happen to her either way. Julian had been smiling for the room since the day I met him. I used to find that magnetic. Now I recognized it as a tool, the same as the watch on his wrist, the black Escalade idling outside, and the woman getting out of its back seat beside him. Her name was Claire St. James, 31. She'd worked in Julian's marketing department for 2 years, then quietly hadn't. She wore a cream coat that probably cost more than my mother made in a month at her old job. I watched them cross the plaza from the passenger side of the Escalade to the courthouse doors. Julian's hand landing briefly on the small of her back before he seemed to remember where he was, and pulled it away. Inside, the elevator up to the 4th floor was slow and crowded, and for a few seconds, all 4 of us stood in it together. Julian and Claire and Renee and me, nobody speaking, the numbers climbing 1 floor at a time like the world's longest 10 seconds. I'd met Claire exactly once before, at a company holiday party 2 years earlier. She'd complimented my dress and called Julian genuinely visionary, in the tone young hires use before they learn that founders pay consultants to put that word in press releases. I'd been polite back. I never imagined I'd watch her walk into a courtroom on his arm. 7 days after I gave birth to his daughter, my husband walked into our divorce hearing next to the woman he'd been sleeping with. He did it with the confidence of a man who already believed he'd won. He had no idea what I was still holding. I met Julian Reed almost 7 years ago at a fundraising mixer in Palo Alto I only attended because a college friend begged me to be her +1. I was 27, working as a research analyst at a firm nobody outside finance had heard of, wearing a dress I'd bought secondhand off a rack on Fillmore Street. The whole room smelled like other people's money. Julian was 32 then, 2 years out from taking Solera Dynamics public, still driving a used Honda Civic he liked to mention in interviews later as proof of how far he'd come. He found me by the drink table. "You're the only person in this room who looks bored instead of impressed," he said. I laughed because he wasn't wrong. I didn't tell him about the Covington family trust that night, or for months after. My grandfather built the family's money in shipping decades before I was born. By the time it reached me, it sat inside a trust managed by people who'd never met the man whose name was on the paperwork. I grew up comfortable and quiet about it, the way old money in California tends to be, because loud money and old money have never quite trusted each other. We married 2 years after that mixer, in a small ceremony in Sonoma his mother called refreshingly modest, her polite way of saying she'd expected a bigger ring and a louder last name. I didn't mind. I liked being underestimated by people who'd never had to be. There was a dinner about a year into the marriage, at the home of one of Julian's early investors in Atherton, stone floors, and a wine cellar bigger than our first apartment. A man I'd just met, somebody's husband, asked what I did all day, clearly assuming the answer involved a yoga studio and a personal shopper. "I used to work in equity research," I told him. He nodded, already looking past me toward Julian across the room. "Well, it's good you get to focus on the family stuff now," he said. Julian laughed along with him, easy, unbothered. And I remember that specifically because it was the first time I understood, all the way down, that my husband had started believing his own origin story more than he believed the real one. There was a real year in there, too. Early on, Julian left the office at 6 so we could cook dinner together in our first apartment on Valencia Street, above a taqueria that made the whole building smell like carnitas every evening. He tested pitch decks on me at that kitchen table and actually changed slides based on what I said. I think that Julian was real once. Success has a way of making people forget which version of themselves actually earned it. 2 years into building Solera, Julian was struggling to close his seed round. I did something I never told anyone, not even my mother, until much later. I had the trust's investment arm, a small, unglamorous fund called Larkfield Capital, write the check that got him through the round nobody else would fund. It went through Larkfield's name, not mine. I called the fund's manager at the time myself, not Arthur yet, his predecessor, a clipped, efficient man named Foster, who handled things the old-fashioned way over the phone, no emails if he could help it. "You understand what you're doing," he said, not really a question. "I understand my husband needs money by Friday or he loses the round," I told him. "That's not what I asked," Foster said. "I know," I said. "Send it anyway." Julian knew, vaguely, that some of his early money came from a fund connected to my family. He never asked for details. I never offered them. I wanted him to love the woman across the table, not the number attached to her name. He called that week the closest he'd ever come to losing everything, and thanked Larkfield's people, a name he never once tried to look up, more than he ever thanked me. I let him. That's the part I got wrong. I thought keeping my money out of it would protect the relationship from it. Instead, it let Julian build a story where I barely factored in, a story where he clawed up from nothing and generously brought along a wife with a modest research job. Forbes ran a piece 3 years into the company's growth, calling him one of the youngest self-made founders on the West Coast. I read it across the breakfast table from him and didn't say anything. At the time, it still felt like a small enough lie to let go. At a dinner party in Atherton around that same stretch, a man I'd just met asked what I did all day, already glancing past me toward Julian before I finished answering. I kept that Forbes issue in a drawer longer than I should have. Not out of resentment, exactly. More a quiet curiosity about how fast a story hardens into fact once enough people repeat it back to you. It stopped feeling small the year I got pregnant. By then, Julian had a chief of staff, a personal trainer, a driver on retainer, and, though I didn't know it yet, Claire St. James. What he no longer had, in his own head, was a wife who'd ever done anything for him except benefit from what he'd built. I became, in his telling, the wife who used to have a job before she had his money. At a fundraiser that spring, I overheard him tell a table of new investors that I'd stepped back from my career to support his vision, as though I'd made a choice instead of watching a story get written for me, one dinner party at a time. I stopped correcting people. I just didn't know yet how expensive that habit was about to get. The courtroom was smaller than people probably picture. No jury box, a long table on each side, a judge's bench up front, and the fluorescent hum that seems to follow every big decision in this country. Judge Patricia Yamamoto presided. I'd read the night before that she moved through family court dockets fast and had no patience for theatrics. The room smelled like burnt coffee and old carpet, the kind of smell that clings to public buildings no matter how many times they're cleaned. Somewhere behind me, a baby that wasn't mine started fussing, and for one disorienting second, my body responded before my brain caught up. Milk letting down like my daughter had made the sound herself instead of some strangers. Julian's side had 5 people, not counting him. 2 attorneys, a paralegal, wheeling a case of exhibit binders, and a communications consultant I recognized from Solera's investor days, sitting quietly in back like she was there to manage optics instead of testify. My side had Renee and me, and an empty chair where my mother had offered to sit. I'd asked her not to. I wanted Julian to see exactly one calm person in that room, just me. Julian's attorney, Gregory Voss, stood first. Tall, from a firm with his name nowhere on the letterhead, but his fingerprints on every case that mattered to people like Julian. "Your Honor, my client is prepared to be reasonable," he said. Mrs. Reed would keep use of a family vehicle, $18,000 a month, and standard visitation, pending final custody. $18,000 sounds like a lot of money to most people. It is, until you remember the house alone cost more than that to maintain. Until you remember there was a company worth over $2 billion sitting on the other side of that number. Until you remember it wasn't generosity being offered at all. Renee didn't so much as glance at the number. She'd told me on the steps outside not to react to whatever they opened with, because the opening number is never the real number, It's just the first test of how hard you're willing to push back. Reasonable how? Beyond the number? Judge Yamamoto asked, not looking up from her file. My client wants a fair settlement that reflects Mrs. Reed's contributions to the marriage, while also reflecting some complicating factors that have recently come to light. What complicating factors? Gregory Voss glanced at Julian. Julian didn't look at me. He looked at the judge with the exact expression he used in every keynote I'd ever sat through. Steady, warm, a little rehearsed. Your Honor, I love my daughter. I want that clear from the start. But paternity hasn't been confirmed, and given some of Mrs. Reed's behavior the last several months, I think the court should proceed carefully before making anything permanent. Renee's hand found my knee under the table before I realized my own hands had curled into fists. Behavior, Judge Yamamoto repeated. There have been concerns, Gregory Voss said, about Mrs. Reed's emotional stability, particularly since the birth. We have documentation we'd like to introduce. Judge Yamamoto finally looked up from her file. I'll want to see that documentation before I give it any weight in this courtroom, she said, and something in her tone made Gregory Voss glance down at his own notes like he was suddenly less sure what was actually in them. I want you to understand what it feels like to sit in a hard plastic chair 7 days after surgery and listen to a room full of men in expensive suits debate whether you're stable enough to keep your own child. It doesn't feel like anger. Not right away. It feels like your whole body going very still. During a pause while the clerk found a document, Julian finally turned and looked at me for the first time all morning. You look tired, he said, quiet enough that only I could hear it. Something almost gentle in it, the voice he used when we were first dating. For half a second, some old part of me almost leaned toward it. Then I thought about the Fairmont, and it stopped. I had a baby a week ago, Julian, I said. What's your excuse? He didn't answer. 2 seats down, Claire looked at her phone like it had just lit up, though I never heard it buzz. I kept both hands flat on the table in front of me, the way Renee had coached me to the night before, because a shaking hand reads as guilt to a room full of strangers, even when it's just exhaustion. Your Honor, Renee said, rising, we're aware of the paternity question and prepared to resolve it today, if the court would like. As for my client's, quote, emotional stability, I'd remind counsel we're 7 days removed from childbirth. I'd caution the court against treating a postpartum body as evidence of anything except recently having given birth. Judge Yamamoto looked up for the first time. Noted. Let's proceed. Julian still hadn't looked at me again. He'd built a company on the principle of not making eye contact with a problem until he'd already solved it his way. Sitting there, I think he genuinely believed this was just another one of those. He had no idea I'd already spent 4 months solving it first. 4 months before that hearing, I found a receipt. That's the whole unglamorous start of everything. Not a confrontation, not a slipped phone, a hotel receipt from the Fairmont on Nob Hill, tucked in the pocket of a garment bag Julian asked me to send to the cleaner. 2 nights, a junior suite, paid on a corporate card that technically belonged to Solera Dynamics, dated a week I remembered clearly because I'd been in Marin visiting my mother, 7 months pregnant, completely unaware my husband had booked a hotel 11 minutes from our own house. I stood in our closet holding that receipt for a long time, long enough that my legs started to ache from the swelling, before I folded it back into the pocket exactly the way I'd found it, and sent the bag out to be cleaned like nothing had happened at all. I didn't confront him that night. I was 7 months pregnant, and some practical part of me knew that whatever came next needed to happen on my timeline, not in the middle of a fight I could lose simply because I was too exhausted to think straight, so I did what I've always done with numbers that don't add up. I got quiet and I started looking. Finding Clare Street James didn't take long. Understanding what Julian had actually built, with me and without me, and how little he'd ever admitted the difference, took a lot longer. Solera Dynamics went public 2 years ago at a valuation north of $2 billion, and every article about it told the same story. Garage, ramen, credit card debt, triumph. Not one mentioned Larkfield Capital, because Larkfield had been structured, at my family's insistence, as a silent investor. Preferred shares, informational rights, a board observer seat I'd never once used. On paper, Julian owned and controlled the company. That was the story, and I let it be the story, because I never thought I'd need it to be anything else. My grandfather built the family's money in shipping after the war. By the time it reached me, it was mostly a trust, run by people I rarely spoke to. I'd met the trustee, Arthur Bellwether, exactly twice in my adult life before that year, a soft-spoken man in his 60s who worked out of a small office in Wilmington, Delaware. He called me the week after I found the receipt and asked, gently, whether I'd ever actually read the Larkfield investment agreement myself. I hadn't. Almost nobody in my position ever does. There's no rush on my end, he told me, but I'd read it this time, start to finish. Why now? I asked. You've never brought it up in 7 years. Because you never asked, and because I think you're about to need to know exactly what you're holding. Know for what? I asked him. He was quiet for a second on the other end of the line. For whatever you decide to do next, he said. That part's always been yours, Mrs. Reed. I just make sure you've got the whole picture before you decide it. I spent 3 nights after my daughter went down reading a document I should have read 7 years earlier, until Arthur walked me through, patiently, what a material misrepresentation trigger actually meant, and what it would mean for Solera if one were ever formally established. He mailed me the original agreement on paper, because he said some things deserve to be read that way. My own handwriting was in the margin of page 38, one word underlined twice. Fine. I'd signed off on it in about 90 seconds 7 years earlier, eager to get Julian his check, never imagining I'd need to understand what I'd actually approved. Reading it now, 7 years later, felt less like catching up on paperwork and more like meeting a much younger version of myself who'd trusted a man enough to sign whatever put a check in his hands faster. Here's what it came down to. Larkfield's original investment included a standard control provision, the kind most early-stage founders sign without reading closely, because they're desperate for the money, and the lawyers on the other side are patient and very good at their jobs. More than once during those 3 nights, I almost called Arthur back and told him to forget it, to let the marriage end quietly, without ever pulling a thread that reached all the way into a company worth $2 billion. I thought about what it would mean for my daughter to grow up as the girl whose mother took her father's company. Then I thought about the folder I hadn't even found yet, the one with her initials on it, and I kept reading. If certain conditions were ever triggered, misrepresenting the company's ownership to later investors, for one, Larkfield's shares could convert into serious voting weight on Solera's board. I'd become the controlling beneficiary of the Covington family trust, and by extension, Larkfield, on my 30th birthday, 2 years before any of this. Julian sent me flowers that day. He never once asked what I now controlled. I used to think that was carelessness on his part. Sitting in that courtroom, watching him talk about my emotional stability, I understood it differently. He'd simply never thought to consider me a variable worth accounting for. So when Gregory Voss stood up in that courtroom and started talking about my emotional stability, He wasn't just underestimating a postpartum woman in a plastic chair. He was underestimating the one person alive who could pull the floor out from under Solera dynamics without raising her voice. A former colleague from my analyst days recommended Renee Castellano. "You don't want a divorce attorney," she told me. "You want someone who used to prosecute fraud." Renee had spent 6 years at the U.S. Attorney's Office in the Northern District of California before moving into family law. The first time we met, in a conference room overlooking the Bay Bridge, she asked me one question before anything else. "What do you actually want out of this?" "I want the truth on the record," I said, "whatever that costs." "All right," she said, "let's get started." She didn't ask me a single question about my feelings that first meeting. She asked about bank accounts, business cards, calendars, anything with a date and a signature on it. It was, strangely, the most comforting conversation I'd had in months. Renee's investigator was a retired SFPD detective named Marcus Delgado. Heavyset, unhurried, the kind of person who talks like he's got all day even when he doesn't. He told me during our first meeting that 22 years on the force taught him guilty people almost never delete the evidence. They just convince themselves nobody's ever going to go looking. He was right. Julian's assistant had kept his travel bookings in a shared calendar system nobody had updated the permissions on in over a year. A small, boring oversight that ended up mattering more than almost anything else in the case. Marcus worked out of a cluttered office above a dry cleaner in the outer Sunset, and the first time I met him in person, he had 3 different case files spread across his desk that had nothing to do with mine. Each one, he told me, belonging to somebody who'd once sat in the same chair I was sitting in, certain nobody would ever find what they were looking for. Over the next 4 months, Renee's team quietly subpoenaed hotel records from 3 properties Julian's assistant had booked, cross-referenced against Solera's own investor calendar, which his office had been sloppy enough to leave accessible once litigation began. The Fairmont receipt was just the first thread. 2 more stays turned up at a boutique hotel in Sausalito, both timed to weekends. Julian told me he was in Austin meeting investors. Then one at a 4 Seasons in Los Angeles, 9 days before my due date. The same week, Julian stood in our kitchen and told me he couldn't make my final ultrasound because of a board meeting. I went to that appointment alone. The technician asked if anyone was joining me. "Not today," I said, and my voice came out steadier than I felt. About 2 months in, I thought Julian's people had caught on. His chief of staff called my cell directly, which had never happened before, and asked, in a tone trying hard to sound casual, whether I'd had any unusual contact with former Solera employees lately. I said no, which was true in the narrowest sense, since I'd never actually spoken to Claire, only about her. I hung up and sat in my kitchen for 10 minutes, waiting to see if anything else was coming. Nothing did. I called Renee anyway that same afternoon, just to be sure. "Did we trip something?" I asked her. "No," she said, "but somebody over there is nervous, which means somebody over there already suspects what we're going to find before we even find it." She was right, as it turned out, though it took us another 6 weeks to understand exactly what she meant. Renee's team kept working, quieter after that, routing everything through a separate channel. The paternity question turned out to be its own ugly little story. Gregory Voss floated it in court like a live possibility, but Renee found the email chain underneath it. Julian, 3 weeks after our daughter was born, quietly requesting a private paternity test through a clinic in Marin. Not because he had any real doubt, because his own attorney suggested, in writing, that even raising the question publicly would create negotiating leverage during the settlement. I read that email 4 times before I fully believed a person could think that way about his own child. I sat with my daughter asleep on my chest for almost an hour after I read that email, not moving, just breathing with her, trying to figure out how a person got from wanting a child to treating that same child's paternity as a bargaining chip. I forwarded it to Renee at 2 in the morning, awake anyway, with a newborn who hadn't learned the difference between night and day. She wrote back within the hour. Now we're building something. Julian called me directly exactly once during those 4 months, a Sunday evening in my 7th month, while I folded tiny clothes on the bed that used to be ours. I know things have been off, he said, but I want you to know none of this changes how I feel about the baby, about us. I didn't mention the receipt. I didn't mention Larkfield, or Arthur, or the nights I'd spent reading a contract I should have read years earlier. I just said, "Okay, Julian," and let him believe, for a few more months, that he was the one managing me. The worst part wasn't the affair. It wasn't even the paternity test. It was a folder Marcus found on a shared drive Julian's chief of staff had accidentally left open during an unrelated file transfer. A folder labeled, with no apparent irony, MC Narrative. MC Maya Covington. Inside were draft talking points for Gregory Voss. A list of concerning incidents that had never happened. Quotes attributed to friends of mine who, when Renee's team reached out, said they'd never spoken to anyone from Julian's camp at all. A memo suggesting they hire a forensic psychiatrist willing to review second-hand behavioral reports and produce a preliminary opinion on postpartum instability, without ever examining me. There was a second document in the same folder, a shorter one, time-stamped 2 weeks after the first. A revised version where somebody had added a note in the margin. Good. This plays well if it gets in front of a judge who's had a rough custody week. I read that note more times than I'm proud of. One line in that memo I still think about more than almost anything else from those 4 months. Given the timeline, a narrative around postpartum psychological strain will be difficult for opposing counsel to challenge without appearing to minimize a real medical condition. Recommend proceeding. They were going to use the fact that postpartum struggles are real and hard to argue with in public as a weapon against a woman who'd never shown a single symptom of any of it. They were betting that decency would stop me from defending myself too hard, because defending myself too hard might look, to the wrong person, like exactly the instability they'd invented. I sat with that folder open on my laptop for a long time. Then I closed it and called Renee. "Let's use their folder," I said. When the recess ended, Judge Yamamoto came back with a fresh cup of water, and her jaw set in a way it hadn't been before. Gregory Voss looked like a man who'd just spent 15 minutes learning things from his own client. He very much wished he'd known that morning. Julian's communications consultant, the one who'd been sitting quietly in back all morning, had moved 2 rows closer to the exit. Nobody else in the room seemed to notice her do it. I did. Renee stood up slow, the way I'd watched her do exactly once before, in the conference room the day she told me we were ready. "Your Honor, counsel raised 2 issues this morning, paternity and my client's emotional stability. I'd like to resolve both, and raise a third the court hasn't heard yet." Judge Yamamoto nodded. "Go ahead." Renee set the first folder down. "This is the paternity test Mr. Reed requested 3 weeks after his daughter's birth, from a clinic in Marin County. 99.9%. He's had this result for 6 weeks. He raised the question in open court anyway." Julian's paralegal stopped flipping through her binder entirely. Julian's jaw tightened. He still hadn't looked at me. "Second," Renee set down a thicker folder. Hotel and travel records from the Fairmont, a property in Sausalito, and a 4 Seasons in Los Angeles, cross-referenced against Mr. Reed's own investor calendar. On each date, he told my client he was traveling for business. Corporate card records show he was accompanied, each time, by Ms. Claire St. James, a former Solera employee. One stay was 9 days before Mrs. Reed's due date, the same night Mr. Reed told her, in their own kitchen, that he couldn't attend her final prenatal appointment because of a board meeting. No such meeting appears on Solera's official calendar for that date. Judge Yamamoto made a note on her legal pad without looking up, the kind of unhurried note that somehow felt louder than anything anyone in the room had said out loud. Behind me, I heard Claire shift in her seat. I didn't turn around. Third, Renee set down a single sheet. The court should be aware of a document titled MC Narrative, authored by members of Mr. Reed's legal and communications team, outlining a plan to suggest postpartum psychological instability on my client's part, absent any clinical evaluation and absent any factual basis. I'd like this entered into evidence. Gregory Voss was on his feet. Your Honor, that document was obtained through legal discovery, same as everything else on this table. Renee didn't raise her voice. She didn't need to. I'd direct the court to one line specifically. She read it flat, no drama in her voice at all, which somehow made it worse. The sentence about postpartum strain being difficult for opposing counsel to challenge. I watched something shift in Judge Yamamoto's face. Not surprise. Recognition. The look of someone who'd seen this particular move before and hated it exactly as much each time. Mr. Voss, Judge Yamamoto said, setting the page down, I'm going to need an explanation for this document before we go any further. Gregory Voss opened his mouth. Nothing came out for a beat that felt a lot longer than a beat. Your Honor, I'd like to request a recess to confer with my client. You can confer. I'm not striking this from the record first. Julian stood, which his own attorney clearly hadn't wanted. Your Honor, if I could say something. Judge Yamamoto looked at him with the patience of someone about to allow exactly one sentence. I never approved that document, Julian said. My team drafted it. I didn't sign off on using it. Mr. Reed, Renee said, before the judge could respond. Your name is on 14 email threads discussing this strategy, including one from 3 days ago where you wrote, quote, as long as it doesn't trace back to me personally, do what you need to do. The room went quiet. Julian sat back down and didn't try again. Gregory Voss didn't look at his client again for the rest of the hearing. I noticed that too. I looked at him, finally. He was staring at his own hands like they belonged to somebody else. Claire had her arms crossed, eyes fixed on some spot on the wall past the judge's bench. Watching her, I understood she'd probably believed at least some version of the story Julian sold her too. That I was the unstable one, the difficult one, the wife he was generously moving on from. During the recess, I sat in the hallway on a bench that had clearly hosted 1,000 other shaking, exhausted people before me. Renee sat beside me and didn't say much, which I appreciated more than any pep talk. At one point, Claire walked past toward the restroom. For a second, our eyes met. I didn't say anything. There wasn't anything left to say that the folder hadn't already said better. She didn't apologize. I hadn't expected her to. I don't know what I would have done with an apology from her anyway, 7 days postpartum, sitting on a courthouse bench with nothing left in me to spend on somebody else's guilt. Nobody said my name for almost a full minute when we reconvened. Nobody needed to. The folder said it for them. Judge Yamamoto closed the folder in front of her, squared its edges against the table, and looked, for the first time all morning, directly at me instead of at either attorney. Judge Yamamoto didn't take long after that. She granted me sole legal and physical custody of my daughter, with visitation for JULIAN contingent on a court-ordered psychological evaluation, which I'll admit gave me one small, quiet moment of satisfaction. I didn't smile in the courtroom when she said it. I saved that for the parking garage, alone, sitting in the car for a full minute before I turned the key. She awarded me the house in Pacific Heights, too, citing the pattern of financial concealment and the fabricated instability claim as factors weighing against JULIAN's credibility on essentially every other point in dispute. JULIAN's evaluation ran 6 weeks with a court-appointed specialist. I never saw the full report, but Renee told me it flagged a pattern the specialist called strategic minimization of partner contribution, a very clinical way of describing exactly what I'd lived through for 6 years. Visitation ended up structured around 2 supervised afternoons a week, up for review after 6 months, contingent on completing a court-mandated program. He completed it. I'll give him that. Whether it changed anything in him beyond what the court required, I honestly can't say, and I've mostly stopped trying to guess. JULIAN didn't argue any of it. By that point, I don't think even Gregory Voss believed there was anything left to argue with. Outside on the courthouse steps, a photographer got one shot of me before Renee stepped smoothly in front of the lens. "Not today," she told the photographer, in the exact tone she'd used with Gregory Voss all morning, and he actually lowered the camera. It was probably the first photo taken of me in years, where I wasn't standing half a step behind JULIAN in the frame. What I hadn't expected was how fast the rest of it moved. The MC narrative folder didn't stay contained to family court for long. Divorce filings are public record, and a reporter who'd covered Solera for years picked up the story within a week. Not because of the affair, honestly, because of Larkfield Capital, sitting right there in an exhibit list nobody on JULIAN's team had thought to redact. Across 3 funding rounds, JULIAN had described Solera's ownership to investors as founder-controlled, with no material outside voting influence, a phrase his own securities lawyers signed off on, and a phrase that stopped being true the moment my 30th birthday came and went 2 years earlier. Whether that was a lie or just years of nobody looking closely at his own cap table, I don't know, and I'm not sure it matters anymore. What matters is Solera's board opened a formal investigation into asset misrepresentation within a month, and JULIAN took what the company's press release generously called a voluntary leave of absence not long after. Solera's stock dropped almost 18% over the next 2 trading days, the kind of number that gets written up in the Wall Street Journal, whether or not anyone involved wants it to be. One outlet ran the headline, "Silent Partner No More," with a photo of Solera's headquarters lobby instead of either of us, which was, of all the coverage that week, the version I minded least. A financial reporter who called my office for comment got a polite decline, and nothing else. I'd spent 6 years being talked about by people who decided who I was without asking. I wasn't going to hand anyone a quote to build the next version of that story. The board brought in outside counsel for an ethics review, and Larkfield, on Arthur's recommendation and with my sign-off, converted a portion of its position under the exact provision JULIAN never bothered to fully understand. For the first time in Solera's history, a voting seat on that board belonged formally to a Covington. I haven't used it for much, beyond making sure the severance packages JULIAN's restructuring plans would have cut got protected in the settlement. Some things you fight for on principle. Some you fight for because it's the right use of leverage you never asked for. Last I heard, JULIAN was still on leave. I don't check as often as people probably think. Claire left Solera entirely, quietly. No press release. I don't know what happened between them after the hearing. For the first time in almost a year, I found I didn't need to know. I heard secondhand that she'd moved back home to Oregon to be near her family. I hope that's true. I hope it was a soft landing. I mean that, mostly. The coverage wasn't unanimous in my favor either. A couple of business columnists spent a paragraph wondering whether I'd weaponized a family trust against my own husband, as if defending a provision I hadn't even fully understood 4 months earlier was somehow more aggressive than what had actually been done to me first. Renee told me not to read the comments. I mostly listened. My mother called the night the verdict came down. She didn't say I told you so, though she'd earned the right to, given how many Sunday dinners she'd spent quietly worried about the man I married. She just said, "Your grandfather would have liked her," meaning my daughter. And then, after a pause, "He would have liked watching you do this too. He always said the Covingtons were patient people. I don't think he meant it as a compliment back then. I think I finally understand that he did." I held the phone to my ear long after she'd said goodnight, listening to nothing, my daughter asleep against my shoulder, both of us finally still. I used part of the settlement, and more of my own trust, to start something I'd been thinking about since the night I sat alone with the MC Narrative folder open on my laptop. I called it the Covington Center. It runs out of a modest office south of Market, staffed by attorneys and financial counselors who work with people, mostly women, being financially or psychologically cornered by a partner with more money and better lawyers than they have. We opened with 4 attorneys and 2 financial counselors. In our first year, we worked with just over 200 clients, most of them women, a handful of men, all of them facing some version of the same problem: a partner with more resources and a willingness to use them as leverage against someone too exhausted or isolated or financially dependent to fight back on equal footing. One of our first clients, a nurse from Oakland named Denise Whitaker, almost signed away custody of her twin boys because her husband's attorney convinced her, informally, over coffee, that fighting it would just make her look unreasonable in front of a judge. She told me later that the only reason she called us at all was that a friend of a friend had mentioned the center's name in a Facebook group for parents going through custody battles, one line in a thread of hundreds of comments, easy to scroll right past. We got her a fair outcome in 5 months. She still sends the center a card every year around the time her case closed. It's the only kind of thank you note I actually keep. We've since opened a second location in Sacramento and a hotline that runs 6 days a week, staffed partly by volunteers who found us the way most people find anything that actually helps: word of mouth. A friend of a friend, a lawyer who quietly passed along our number instead of billing another retainer. None of it makes headlines the way the Larkfield story did. I've come to prefer it that way. We turn away more people than we're able to help, still, which is the part of this work that keeps me up some nights more than anything from the divorce ever did. We're working on funding for a 3rd location now, in the Central Valley, where Renee tells me the need is even greater and the resources are even thinner. I think about that folder often. The plan wasn't really about me, specifically. It was a strategy Gregory Voss's firm had probably used before, and has probably used since, on some other exhausted, sleep-deprived woman who didn't happen to have a family trust with a control provision buried on page 40 of a term sheet. I got lucky, in the one specific way that let me fight back. Most people don't. That's the whole reason the center exists. My daughter is 2 now. She has no idea a folder with her initials on it almost decided what her childhood would look like. Someday, if she asks, I'll tell her the truth. That her father built an empire on money he never fully understood the source of. That he tried to use her birth as leverage in a negotiation, and that none of it worked. because her mother had spent her whole life being quietly underestimated and finally let that work in her favor instead of against it. I keep the Forbes issue in that same drawer still. Some days I think about throwing it away. Most days I don't, because it reminds me what a story sounds like before somebody goes back and checks it against the truth. I didn't set out to win anything. I just stopped letting him write the story alone.
If you were in Maya's shoes, would you have fought back this hard or chosen peace instead? Let me know in the comments and subscribe for more stories.